Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Noor Safii Atirah Binti Zainudin. My matric number is 1201596. Today I'm gonna talk about my case review. My case name is Taurah bin Abdul Hamid versus Junaida Binti. This case was scheduled for mention on November 21st, 2010. The plaintiff was sought a court order to include the following properties as harta semicarian. The first one is Lot 4315 in Jerangau Dungun, B Lot PT3970 in Jerangau Dungun, shares in Koperasi Serbaguna Felda Jerangau Terengganu Dungun, and shares in Koperasi Pemodalan Felda Berhad. This asset had been overlooked and were now to be included, addressed, and distributed in accordance with the Sharia High Court's consent judgment. Next is parties involved. Parties involved: Taurah bin Abdul Hamid as the plaintiff in this case. Taurah is living in Jalan Emas 1, Taman Emas, Batu 30, Hulu Yam 44300 Batangkali, Selangor. The plaintiff is the son of Abdul Hamid bin Karim from the previous case that happened on November 18, 2002. Next is Junaida Binti as the defendant in the case. Junaida is living in Felda Pasoh 3, 72200 Batu Kikir, Negeri Sembilan, and she is not represented by any Syariah lawyer. And this defendant is the daughter from a defendant from the previous case that happened on November 18, 2002. The first issue is properties to be added to the consent judgment. It is whether the court allowed the addition of asset to mention inherited property. In this case, the court allowed it when it was also agreed by both parties through a settlement of suluh. Next is parties not residing in Terengganu, as this issue pertains to the court's jurisdiction in the event of matrimonial property and land claim when both parties do not reside in the same state as the same claim. The question is whether a plaintiff from Selangor can file a claim in the Terengganu State Sharia High Court against a defendant from Negeri Sembilan because the land and other properties are in Terengganu. The plaintiff who resides in the state of Selangor makes a claim against the defendant who resides in the state of Negeri Sembilan Terengganu Sharia High Court because the land and other property claim are in the state of Terengganu. To answer for this issue, this case is dispute about property that has an exception in terms of the court's jurisdiction. Originally, the jurisdiction of the court for a case to be tried according to the place of residence of the accused, meaning the defendant of the case. In contrast, the location of the property determines the jurisdiction for cases involving property. For instance, this case was heard in Terengganu because the property is there, even though the plaintiff lives in Selangor and the defendant lives in Negeri Sembilan. Next, whether matter within jurisdiction of the court. A judge's qualification to hear a case becomes an issue. This situation involving property, necessity, examination, and attention. As a result, it's critical to locate the evidence obtained in the area surrounding the property because it's more extensive and clear. The judge's location determination provides two benefits. First, it assists the judge in making an accurate and proper case decision because the judge understands the issue. Second, expedite the case and save the judge money on investigation and discovery of the truth. According to Sharia and legal requirements, in this case of a property of allegation, the judge or court with jurisdiction to hear and decide on it is the judge or court where the dispute property is located. The Terengganu Sharia High Court has jurisdiction to hear and decide the claim according to the provisions of Sharia law and the law as mentioned above. Next, argument by the parties. The plaintiff demanded that the court make the following comments: the land, a wooden house, the shares in Felda Capital Cooperative that amount to 900, And the argument and defendant from this case agreed in everything that plaintiff had been asked for from the judge. Next, had the lawsuit was settled by the parties' consent, with the defendant agreeing to all the parties' plaintiff claims. The defendant's action in consenting to all the plaintiff claims was compatible with Hukum Syara and the idea of suluh. The judge ruled, with the agreement of suluh from the both parties, that assets are the missing or additional property that must be included, settled, and divided according to the consent judgment. Suluh at Terengganu Sharia High Court, Terengganu. From the case happened December. From the case happened on 2002 between the late Abdul Hamid bin Karim and the late of Maria Binti Abu Samah, and the court also ordered that the cost should be borne by each of the party. Next, my comment for this case. Suluh, in my opinion, if a matter can be resolved amicably, this is since suluh has several advantages, one of which is that it saves time because there is no need to do the procedural trial time in court, and the statement in suluh will not be told to outside parties. In addition, the evidence given by the parties involved cannot be used as evidence in court. So we can feel free to discuss in suluh. Discussing together in suluh is highly encouraged so that we can come to a consensus to get a mutual agreement. I agree with the court's decision in this case, which allow additional property in the marital property that has been resolved amicably in suluh. However, in my opinion, the court should elaborate further on the division of each property. This is because there is additional property. For example, from the case of now at RTL versus Sarsa, this case is about the matrimonial property of a divorced couple. The court explained it in detail, saying 2.5%, which is 25,000 shares owned by the respondent, Inqilab Turbin Asia Sendirian Berhad, against the appellant. That's all from me. Thank you.